Before discussing the provisions of the Marriage Act, it is important to understand why it is necessary to actually look at what the law provides. Many people assume that once a ceremony takes place or once a partner says the necessary steps have been taken, a valid marriage automatically exists. However, the law sets out specific procedures that must be followed before a marriage can be legally recognized. Consider this scenario. A woman once believed she was legally married. She lived with her partner as a husband and wife, and they had children together. When the relationship eventually broke down, she applied for her marriage certificate as part of the dissolution process, only to discover that no certificate existed. The man had earlier assured her that he would handle the marriage license and registration. She trusted him and never verified it. What she later discovered was that no license had been obtained and no statutory marriage had ever taken place. In another situation, a spouse filed for dissolution of marriage only for the other party to argue that the marriage was not valid because the place of worship where the ceremony occurred was not licensed to celebrate marriages under the law. In yet another scenario, a party who was already married simply declared the earlier marriage invalid without obtaining a court order and proceeded to contract another civil marriage under the Act. These situations illustrate why the provisions of the Marriage Act are important. Marriage under the Act is not merely a social or ceremonial event. It is a legal institution governed by specific procedures. Understanding these provisions helps protect individuals from uncertainty and unintended legal consequences. It is therefore useful to briefly examine the foundational provisions of the Act, particularly sections 1 to 10.